Welcome to BusinessTraining.com. Today's video module is focused on the Uniformed Services Employment and Reemployment Rights Act. This is our agenda for the video topic today. Please take a moment to review the outline. The Uniformed Services Employment and Reemployment Rights Act, or USERRA, is a federal law that was enacted in October of 1994 that applies to all U.S. employers. It prohibits the denial of benefits of employment, including the hiring of members of the uniformed services, such as the Coast Guard, Navy, Army, and Marines. This includes their membership or obligation of service in the uniformed forces, like those in the National Guard or Reserves, their application for service, including those preparing for basic training, and the performance of service, such as National Guard members being activated to serve on deployments or federal emergencies. It is meant to protect the rights of service members for employment, as well as reclaiming their employment, which we will discuss later on, and act as a protection against discrimination based on military service, just as if it was a racial or gender discrimination protection under Title VII. USERRA is regulated and administered by the U.S. Department of Labor and the Veterans Employment and Training Service. According to the Department of Labor website, USERRA applies to any persons who perform duty, voluntary, or involuntary in the uniformed services, which include the Army, Navy, Marine Corps, Air Force, Coast Guard, and Public Health Service Commission Corps, as well as the reserve components of each of these services. Federal training and service for the Army and Air National Guard applies to USERRA. Certain disaster response work and training for such work is also considered service in the uniformed services. USERRA covers active duty and inactive duty training, initial active duty training, such as basic training, and funeral honors duty, as well as a period of absence from employment an employee may take for an examination to determine their fitness for duty. The Act covers nearly all employees, including part-time and probationary employees, and applies to nearly all public and private U.S. employers regardless of size, as well as any foreign company with physical branches or locations within the United States. The purpose of USERRA and base statement is to prohibit the discrimination against any individual due to past military service, current military obligations, or intent to serve. It prohibits any employer from denying the employment, reemployment, retention in employment, promotion, or any other benefit of employment to those previously mentioned, and states that employers must not retaliate against an individual that has taken an action to enforce, exercise, or assist in obtaining USERRA rights or USERRA investigations. As stated before, an employer cannot determine employment of an individual based on their prior, current, or future intended service in the uniformed services, just as if they cannot do so based on gender or race, unless it can be effectively proven as a bona fide occupational qualification. For example, an American research company requires a lab assistant position to be present for duty for a full year in their base in Alaska, to be competitive in its research in genetics. This can be a bona fide occupational qualification if it can be proven and documented. Employers that have employees that are called up or depart for service, or pre-service employers, are required to re-employ service members returning from their period of service, granted that they meet 5 certain criteria. However, the employee must have been absent on account of service in the uniformed services, including training. The employee must have given the employer advance notice, whether verbal or written, where possible. Although USERRA does not explicitly require timeframes and notification, the Department of Labor and Department of Defense have recommended at least 30 days in advance where capable. There are times when military necessity prevents advance notice, such as when giving advance notice could jeopardize classified missions, or when giving advance notice is impossible or unreasonable due to an extremely short notice to report to duty, such as a call to mobilize in a federal emergency within 24 hours. The third criterion is that the cumulative period of service under the same employer must not exceed 5 years. This 5-year limit is set to protect employers from the backlash of consistently absent employees. So, for an example, an employee in the National Guard has been working for a company for 10 years, and in that time, he has been deployed in 5 different missions of 12 months each. This means that after any future deployments or military absences, the employer is not required to re-employ the service member, though they may on their own accord. There are, however, exceptions to this rule. Those exceptions are if the employee is called up for an emergency, such as a national disaster emergency, reserve training, such as the National Guard's routine of a weekend drill and 2 weeks annual training, or if the initial service period contract is over 5 years, or by order of presidential declaration. So for that last exception, for example, an employee works for a company and decides to join the military to serve. His contract states he will be on active duty for 6 years. This exception allows him to be protected under Userra. The fourth criterion is that the employee must not have been released from service under dishonorable or otherwise punitive reasons, but must have completed his or her service honorably or generally. And finally, the employee must have reported back to work or submitted an application for reemployment in a timely manner, unless doing so was impossible or unreasonable. What constitutes timely reporting will be discussed shortly. Now, Userra states that the employer must reemploy the service member in the job that they would have attained had they not been absent from military service. This is also known as the escalator principle. The employer does not necessarily have to provide the service member with the same job, but they must provide a job of at least equal seniority, status, and pay. Adequate and reasonable efforts must be made to enable the returning employee to be qualified for reemployment, such as training and retraining. Now, if the service member cannot qualify for the escalator position, he or she must be reemployed, if qualified, in the nearest approximation to the escalator position that was held. While on military training or service, employees are considered to be on furlough or leave of absence and are entitled to all of the same non-seniority rights given to other individuals. The escalator principle applies to compensation and benefits as well. For example, if an employee with 2 years of employment earns 10 days of vacation, and 3 years earns 15 days, and a service member is called for military service between 2 and 3 years for 1 year, they will earn 15 days of vacation. The employee also has obligations to the employer, particularly in reporting back to work. There are time limits for returning back to work, which is dependent on the period of military service the service member was performing. For military service that lasts less than 31 days, the employee will return to work by the beginning of the first scheduled work day after his or her last day of military duty, including time to return home safely and an 8-hour rest period. For employers, the health and pension plan coverage continues for the service member as if he or she never left. For periods of service between 31 and 180 days, the service member must apply for reemployment no later than 14 days after his release from service, unless it is impossible or unreasonable to do so. For employers, the service member cannot be terminated involuntarily within 180 days of his or her reemployment. For any amount of service over 30 days, the service member may elect to maintain the employer health coverage for up to 24 months, but may be required to pay up to 102% of the full premium. For purposes of pension plan participation, vesting, and accrual of benefits, Userra treats military service as if it were continuous service with the employer, so any vesting schedule or accrual continues. For military service periods of 181 days or more, the service member must apply for reemployment no later than 90 days, unless impossible or unreasonable to do so. For employers, the service member cannot be terminated involuntarily within 1 year of reemployment. Lastly, if a service member has service-connected injury or illness to where they need further medical care and treatment under military care, the deadlines for reemployment are extended up to 2 years. Employers are required to provide notice of Userra rights, benefits, and obligations of both the employees and the employers under Userra. Employers may do this by posting a notice or poster of the employee's rights under Userra where notices are typically posted, or they may choose to mail or email the information, as long as it is adequately distributed in a manner appropriate and consistent with other forms of employee rights notifications. Be cautious of what employees or managers may be saying. Disgruntled employees upset over the continued absences or long deployments of service members may voice their discontent. Though there is no law against bad attitude against military service, trivial or petty comments will be remembered and even documented. This may come back to adversely affect employers that make a negative employment decision against a service member. Train managers to avoid this and understand the Userra regulations. If an employer fails to comply with Userra rules and regulations, a court may order the employer to compensate for lost wages and benefits. In the cases of disputes between an employee and employer under Userra, There are a number of ways to resolve disputes. An informal discussion between the employee and employer may occur, or the employee may choose to initiate assistance from the National Committee of Employment Support of the Guard and Reserve, or ESGR. More serious is the Department of Labor Veterans Training Service investigation, though this is meant to investigate claims and has no enforcement powers imbued. Even more serious are lawsuits that are filed by the Department of Justice or local U.S. attorney, or one filed by an individual or attorney. Employers need to be aware of compliance and support of Userra and service member benefits to avoid potential legal actions. Here are some frequently asked questions asked by employers on Userra. Do I have to pay an employee while he or she is away on active duty? Userra does not require employers to pay service members while they are on military service. However, some employers voluntarily choose to pay the difference between military pay and allowances and an employee's regular pay. If this is a policy in your company, employers should review these policies to ensure it is non-discriminatory and is consistent with the business objectives and culture of the business. Is an employee entitled to bonuses or pay raises while away? This depends. The escalator principle states that a returning employee is entitled to benefits which he or she would have received if they remained continuously employed. For bonuses or raises that everyone receives, or a scheduled pay raise or bonus for his or her position, yes, they are entitled to it. For individual merit-based raises or bonuses, for example, this is not necessary. What about employees serving in the National Guard? National Guard members perform training, federal service, and even sometimes state service. Userra only applies to National Guard members who perform federal service, but many state laws provide additional protection for service members performing state service. Check with your local state laws for compliance. I have less than 20 employees. Am I excluded from Userra? No. Userra, unlike anti-discrimination laws, does not exclude companies with less than 20 employees. There is no size cutoff. Where can an employer deny reemployment? Reemployment can be denied where a service member fails one of the 5 criteria, such as absences extending 5 years, being dishonorably discharged, or application for reemployment was not timely, where applicable. An employer can also deny reemployment if they can prove, without a doubt, that it would be impossible or unreasonable to reemploy the employee. For these situations, it is best to consult an attorney for legal advice. How is Userra interpreted and enforced? Courts have interpreted veteran laws in favor of service members. Therefore, federal bodies will almost certainly take a pro-veteran and service member stance when it comes to Userra. Can an employer require an employee to use vacation time while on military service? No. Employees are entitled to use vacation time while on leave, but may not be required to do so. Does an employee continue to earn vacation on military service? This is a complicated issue and is not as easily answered as a rate of vacation accrual. Userra does not expressly state that service members will continue to earn vacation while on military service. In some circumstances, 3 statutory provisions may require employees to continue to accrue vacation. The Departments of Labor and Justice have interpreted the regulation very broadly, having to rely on legislative history on whether to expand a veteran's vacational accrual rights. If you would like more information on the Uniformed Services Employment and Reemployment Rights Act, please go to the Department of Labor's website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.